everyone. Welcome to another podcast. This is Felipe, and we're joined again by Lory Rosenberg. Lory, thank you so much for joining us once again.
Hi, I'm happy to be here.
And we're very privileged to have Lory on board, and with her wealth of knowledge and experience in helping us analyze cases and also bringing us good updates so we can get ready for future battles. And also, the key is behind these conversations is to make sure we prepare the kind of case where we don't need to appeal. But today we're going to discuss a case which is very important, Patel. You might or might not have heard of this, but there's a word that immigration likes to throw around. And unfortunately, in some cases, they do have some authority behind it. And that word is discretion. I hate the word, but they throw it around. Immigration judges like to throw it around. And it's our job as defense attorneys to push back and say that there's discretion, but you have to at least state your reasons. And we put up the best fight that we can. So Lory, tell us about Patel. Let's go a little bit into the facts and the holdings and how we can help our clients who have Patel-like situations.
Okay. Well, before we do that, I'm glad you mentioned discretion because I just want to say a couple things about that, pet peeves of mine. The thing about discretion is that we're working with an agency, and the agency engages in its adjudications and renders judgments. And when the case is controlled by the adjudicators or the judge's discretion, many people, including some of the judges and adjudicators, believe that it's, fair play. They can just whatever whim they feel or they get a feeling, even if they can't articulate reasons, they'll say yes or no, depending on oftentimes just a feeling that they have. And the truth of the matter is that although discretion does imply that it's a matter of judgment, and courts do feel oftentimes that they can't get involved and second guess what a judge might have been thinking or feeling, and they won't review the case. The fact is that if you look at most of the, quote, discretionary decisions that are made in the immigration context, there are in fact guidelines that are basically the parameters within which discretion has to be exercised. For example, the most common way that discretion is described in cases involving relief from removal, it's basically weighing and balancing adverse factors against positive factors. And the adjudicator or judge has an obligation to take all of those factors that are in the record into account. So you can say it's just an exercise of discretion. We can't second guess the judge, but the truth is the judge at the very least has to let us know when we're reading a decision that he or she did take those factors into account, because it's not fair otherwise if they weren't taken into account.
So let's say they render a decision. They say this type of application, let's say, 42B, a cancellation or removal for non-permanent residents. The hardship part is discretionary. I hereby find that you did not meet the threshold.
Right.
And that's it. That probably would not be enough. You at least have to state why. You have to go into the record, right?
Yes, it has to be supported by evidence. I mean, there is a concept in law called an abuse of discretion, and to not take into account any of the evidence that is present in the record would be an abuse of discretion. And if maybe the judge did take those factors into account, but if they're not clarified and set out in the decision, we don't know what factors he or she took into account. So yeah, and we'll get back to this as soon as I give a brief introduction to the case Patel v. Garland, and then we can talk about it in more detail. So let's go back to Patel v. Garland. This was a Supreme Court case, and it was issued last year was it 2022 or 2021?
2022 for sure.
Okay.
I don't remember which month, but yeah.
Okay, that's fine. It was in the maybe like May or June, something like that.
Yeah, yeah.
But okay, so the facts in this case are very odd and unfortunate. It had to do with a case that came out of Georgia, in which Georgia is one of those states where when you go to apply for a driver's license, it says it uses the word citizenship in the context of the motor vehicle department, giving you access to this driver's license. And it uses some confusing phrases to get an applicant for a driver's license to check off a box that may talk about citizenship. So Mr. Patel, unfortunately, did check a box when he was going to get his driver's license, and he was not pretending to be a citizen or anything. He wasn't doing anything fraudulent. He just was filling out the form that he was given, and he didn't know better.
And Lory, why would that be a problem if someone fills out something saying that they're a U.S. citizen, whether or not they're meant to do it?
Okay, well, okay. So first of all, the reason that DMV offices do this is that they often try to serve as a location where someone can register to vote. And to vote, you have in federal, state, and even municipal elections, not all, but most municipal elections, you must be a citizen. So they're trying to make things easier for the person who comes into the motor vehicle office to get their license and saying, oh, while you're here, why don't you just fill this part of the form out and we'll get you registered to vote. They don't tell people that, though, and they also don't tell people that they should only do that if they're a citizen. So Mr. Patel made some mistakes, and pretty soon, and the reason that you don't do this, obviously, is because you're not supposed to pretend or act as though you're a citizen if you are not. And so it's also within the law of immigration, claiming citizenship can also be a basis for removal if you are not a citizen. So it has all kinds of consequences that you want to avoid. So, okay, the problem here with Mr. Patel is that they viewed him as presenting himself as a citizen when he, of course, was not a citizen. And so the litigation in his case went all the way from what happened in the driver's license office in Georgia to an immigration removal proceeding, to the Board of Immigration Appeals, and finally to the 11th Circuit Court of Appeals, and then to the Supreme Court. And that's as high as you can go. So the Supreme Court gets the last word. And what they said, basically, just jump in, Felipe, if you have a way of.
I was going to say they get the last word, or sometimes the last laugh.
Well, right, exactly. That could be too. So, but basically, what happens here and what happened in this case is that they looked at the issues and they made some holdings. And they basically said that, number one, you cannot get judicial review. That means review in a district court, a federal district court, or a federal circuit court of appeals, basically, judicial review. It's usually, I should correct myself there, it's usually referred to only when talking about circuit courts. But so judicial review is banned under the law, immigration law, under the statute, when, sorry, excuse me one second. Mm-hmm. Judicial review is banned when you're dealing with a form of discretionary relief listed in the statute, and it covers some of the most common forms like adjustment of status, cancellation of removal, waivers under 212H or 212I for misrepresentations, and sometimes for crimes involving moral turpitude, and so on. So it's fairly expansive. And those are forms of relief that can keep people in the United States with their families rather than being removed or deported to their home country. So it's very critical to get that right at the lowest levels when you're presenting an application. So anyway, what the Supreme Court basically said in Patel is that the statute very specifically precluded review in the Circuit Court of Appeals, and that the question was if what was being reviewed in the discretionary relief context was a question of fact, the circuit courts will not review it. They have a very strict standard of review for factual matters. But if it was a question of law or a mixed question of law and fact, under an exception in the statute, it could be reviewed. So what that tells us is probably the most important factor here in this Patel case and its impact is that we have to look for anything that appears to be raising an issue of law. And mixed questions of law and fact are questions where there has to be a factual determination made, but also it's not enough to just decide the facts. We have to then go a step further and ask, okay, and what happens when we apply the law to these facts? And when
I've seen that previously in some panels you gave examples of this. So for example, what would be a factual statement versus a statement that combines fact and law?
Okay, let's think about that. Oh, by the way, let me just say this. This whole standard we're talking about here does not apply to asylum cases. So yes, that's really good and very important.
Excellent, yes.
Review is very important. And I'm also presuming here without saying that we want judicial review. In other words, we as advocates and attorneys, defense attorneys for immigrants, want there to be as much oversight as possible, because if our clients are denied, it can have a very bad effect on them and their families. So we want to make sure that the highest court possible looks at the case. Sorry, I interrupted.
No. I mean, even the court, a few years ago in Canada, they said, the presumption in favor of judicial review is lofty. It's high. We
yes,
want that. But
yes,
the composition of the court has changed a little bit since then, and
right,
they're taking a different turn. Yeah.
Right.
So,
exactly.
Some differences so the audience can understand a difference between how the government would try to isolate something as purely factual. Maybe in Patel's case, the factual was, was it on purpose, or did you not check off the citizenship box, versus how can you make certain things into a mixed
okay. So so let's take the case of fraud, for example. You can find a fact like, yes, he checked off the box relating to citizenship. Okay. But is that enough to determine that it was a fraudulent action? No. Why is that? Because to be a misrepresentation or to be fraud, you need an intent to defraud. Now, an intent to defraud is a standard. It's one standard. There are many others in immigration law. But an intent to defraud it's not enough to just say, yep, he checked the box. No, you have to say, and his intention was XYZ. Now, how do you determine somebody's intention? Well, you look at certain indicators that would reflect an intention to fool someone or misrepresent something or get away with something. And if that's there in the record, you may be able to establish it. If it's not there, then it will be very difficult to prove intent. Another example of this that might be really familiar to people is the standard for exceptional and or extremely unusual and exceptional hardship, right? So in that case, that is a discretionary determination, and that's been held by the board, judges, other courts, etc., even circuit courts. But the fact of the matter is that it's not just a judgment call. Whether something is exceptional and extremely unusual hardship depends on a number of things. It depends on various pieces of evidence that one would consider. It also depends on taking each and every individual piece in the aggregate. So it's not enough to just say, okay, well, we have these 5 factors. He'll lose his job, he'll lose money, there's a health crisis in his home country, and he'll never see his children. It's not just to say, well, that's what happens to everybody who gets deported or removed. And some courts, some judges will actually say that. But the fact is, maybe not everybody has each and every one of those factors. So if you take each of those evidentiary factors and you put them together, what's the impact of all of those? Maybe it does amount to exceptional and extremely unusual. So it's not enough to just say all these factors are present. You have to go, okay, in the aggregate or taken together, what does this mean? And so the argument can be made that exceptional, extremely unusual hardship is, it may be discretionary because it's a judgment being made by the court, but at the same time, it's also addressing a question of law. What does that standard mean? For example, some standards require only extreme hardship. This one requires exceptionally unusual hardship as well. What does that mean? And when we apply that to these facts that are clear in the record, what's the outcome? What's the result? That's what a mixed question of law and fact amounts to. And in my view, almost every judgment in an immigration case it's almost possible to call everything a mixed question of law and fact, because to make it meaningful, it's not just enough to say, okay, this person came in as a student and has been here 10 years. Those are all factual determinations, and we're not challenging those. But what's the impact of all of those factors on eligibility for a certain form of relief that's discretionary? And so
I have to wonder how much of a fight did Patel put up at the trial level. I don't know if they raised, the kind of arguments that, you're talking about now. I think I remember something where he might have just pled to certain things. I'd have to go back and look, but
yeah,
this is
I
the
don't know
importance.
that either.
Yeah, this is the importance of, can you explain to the audience, the importance of raising certain arguments and what happens if you don't raise them?
Okay, yeah. Well, excuse me, yes. Yeah, it's really important, I believe, to raise these arguments concerning mixed questions of fact and law at the very outset of a hearing or of an application. Even if it's not necessary to make that point now, they still should be put in the record, and evidence, for example, evidence of how they interrelate with one another and what the totality of the circumstances means to the individual involved. All of that needs to be raised at the very beginning. There's a reason for that. One is you want to make sure that you're including a way to look at the evidence that will allow you to argue later that this should be viewed as at least partially a question of law, but also you're helping to educate the court. You're helping to help the court to see, oh, wait a minute. This is not just, was he here for 10 years or 11 years or 12 years? It's how does that impact on the level of hardship that we have to establish? That gets you into the territory of questions of law. And there's another reason that it's important to raise these things at the very beginning. And that is, there's a concept called exhaustion of administrative remedies. So, if you don't raise this and you go to the Board of Immigration Appeals and then you go to the Circuit Court of Appeals, the Circuit Court, they're not only going to say, this involves discretionary relief, so we can't review it. They're going to say, even if we could review it, you failed to raise it before the agency. And that means you didn't give them a chance to remedy the problem. And that's what it means.
It's so unfair, because how is a client going to know that he won't know, he or she won't know? It's right. Up to the attorney and the quality of the attorney that they employ. Yeah.
Right. And that is a good reason why a person without an attorney to represent them is prejudiced in removal hearings, and why we encourage people to get either private counsel or pro bono counsel, legal services of some kind. It's critical because you can't expect the average person to know how you're going to have to frame your issue so that later when you get to the Federal Court of Appeals, they will consider you.
And even many attorneys don't raise this stuff. They'll plead, the basic form of relief I'm seeking is this, so I'll plead to, the allegations, and I don't really raise it very much. And it
right. And and so most of these forms of discretionary relief do have applications that you have to fill out, right? So like there's an adjustment application, an I-485, or there's a cancellation application, what we refer to as the 42B. And they do include some boxes to check that can reference some of these factors that we're talking about, but oftentimes they're just very straightforward questions of when did you last enter? Are you married? Are you not married? When did you get married? Have you been married before? And it looks like it's very straightforward. And I know a lot of clients come into lawyers and they say, okay, I can do this on my own, but after I fill out the form, will you just look it over for me? Well, that's just not good enough. It's not good enough because every one of these cases requires an analysis and a strategy over what's going to be the best presentation so that the court will feel comfortable agreeing with you or agreeing with your client and getting the result that your client wants. You can't just walk in there and expect the judge, or if you're applying with USCIS, you can't just go in there, file the form, and expect them to do the work of putting it in the best light for your client's needs.
Absolutely. Lory, so essentially, the holding in Patel is that the judge, the immigration judge, USCIS is something else we have to talk about. The immigration judge has discretion over certain forms of relief, like an adjustment of status application, when it comes to factual determinations. Is that more or less the holding in Patel, or what would you add to that?
Okay. No, I would say that basically Patel is, the holding in Patel, I think, is saying that judicial review of discretionary relief listed in the statute in section 8 U.S. Code 1252 um, B2 capital B little I, that statute says very explicitly that there is no judicial review, which means in the Court of Appeals, of these forms of relief. And then it lists the specific forms of relief in the statute. So what Patel is saying is that the basic presumption or understanding is that no, you cannot get review of those forms of relief, but it acknowledges that there is an exception. And historically, when the last time the legislation really had a complete redoing, the Congress said, okay, we are limiting judicial review, but because of that, we're going to put in what's called a savings clause or an exception. And that exception is in B2 capital D, where it says that notwithstanding the holding in Patel or the 1252 little b to capital B little I, notwithstanding that, if the question presented is a question of law or a constitutional question, that's so important that Congress wanted courts to be able to have a say on whether or not the underlying decision was correct.
And that's why you've been hammering mixed questions of fact and law.
Right.
So D can apply, right?
Right, exactly.
Perfect.
And what that means is that you have to know how to look at different issues in your client's case and different situations. First of all, the first thing to remember is that what the statute says is that the application of law to settled facts. That means, no, the court will not review facts that have been found by the immigration judge, upheld by the Board of Immigration Appeals. Those are settled facts, or maybe everybody agrees with the facts and they were never in dispute. So settled facts or undisputed facts never get reviewed. But the question is, what does it mean to apply a standard like extremely unusual and exceptional hardship? And what does it mean to apply a standard to different kinds of settled facts when we're looking for review in a court of appeals? And what does that standard mean? That's a question of law. And it's essential that you consider what that legal question is. And the legal question, may be, is it enough? Is it enough hardship? Is it an unusual or exceptional hardship? How extreme is this? Is it enough to satisfy the language that Congress put in the statute? And, the thing that's kind of interesting when you look at adjustment cases that are prepared on I-485 forms versus cancellation cases, adjustment of status is a form of discretionary relief. But it's not because there's an internal standard that has to be met, like exceptional, extremely unusual hardship. In adjustment cases, you need to have your approved I-130 or I-140, which means you've complied and satisfied the terms of those provisions of law. And then after all of that is presented to the court, you need to satisfy the court, the judge, that the application should be granted in the exercise of discretion. Yes. So that's a broader discretionary standard in a way, because you're not looking for hardship or extreme hardship. And that is more likely to be argued, well, there isn't really a specified standard here. You know, who are we to substitute our determination for what the judge found? So it's important to point out that the exercise of discretion itself has guidance or law that has developed that applies to it. And one really important point there is that when something has to be decided in the exercise of discretion, it means that the decision maker has to look at all the favorable factors that militate in favor of granting the relief and all the adverse factors that may be prior immigration violations. It could be criminal convictions. It could be other suspected fraud or other bad action that the court feels makes this an unworthy person. So what that means is this: if you're the attorney, you have to put in positive factors and adverse factors, and you need to explain, look how many positive factors we have here. It's an overwhelming amount, and that could be goes to church, supports his family, you know, coaches soccer, is a good worker at his job, you know, is a good community member, et cetera, et cetera. And the adverse factors, what you want to do there is you don't want to hide them. You want to bring them out, but you explain, were there mitigating circumstances? You know, was he picked up driving over the speed limit, but on trying to get his wife to the hospital because she was giving birth? You know, what are the factors that, yeah, it might sound bad, but we're going to let you know that this was kind of beyond that person's control. So that means the job of the attorney is really important. And or the job of the applicant, if there's no attorney. And if you're the attorney, you really want to be thorough. That means you have to thoroughly interview that client. You have to learn about their background, their history, their, you know, good deeds, their bad deeds. And then you have to get the explanation. Why did you do this? You know, okay, you and your wife had to go to court over a claim of domestic violence. What was going on there? What happened? Did you both then take a course in domestic violence or in anger management? Okay, great. That looks like you took responsibility and you tried to get over a mistake that had been made. So those are the kind of things when you have a discretionary determination that you need to put in the record. And if you don't, if they're not there, the judge is not responsible to find them. And the judge is not responsible to do anything to help you build your case. Only your attorney can do that, or only you yourself can do that. So that's, you know, in the discretionary determination, you have to look at the statute and at the regulations to see if they're giving you a hint of what are the kinds of things. They could be facts, but they also could be other considerations that the judge needs to be made aware of so that the decision can actually not be an abuse of discretion, but can be a reasonable and reasoned fair exercise of discretion.
Beautiful. I think this, you know, really teaches us, you know, just be careful and build the best possible record that you can. And the initial application, if you're in court, you know, like Lory said, you know, you have to build the record. The judge can't make it for you. And the judge, at least they're not supposed to make a ruling based on personal knowledge of certain circumstances. It has to be on the record. Country conditions, you know, relating to China, yeah, we know there's a lot of religious persecution there, but if it's not on the record, the judge cannot make that finding. You have to put it in there. And the importance of aggressive representation. Of course, you're not going to bulldog your way in there. There's a certain level of diplomacy. You have to try to get people on your side to the extent possible, but you also have to make your record, right? And if you don't raise certain things, it's going to be hard for Lory or whoever's working on the appeal, if you get an adverse ruling, to argue that you did raise it at the trial level so you can preserve that record. Who knows? Maybe Patel's fate would have been different had, they'd done a better job of preserving the record, so that subsection D could apply instead, right?
Right. You have to make sure there's a question of law there. And, one thing that I think we should mention here is that oftentimes, now, a lot of times it doesn't work, but oftentimes the government attorney might be persuaded to agree with you. Like if you have a really clean case, especially an adjustment, your client is a good guy or a good woman and has, done everything correct and, followed the law, etc., you might approach that attorney for the government and say, would you be willing to stipulate or agree with me in court that everything that's needed is here in this application and that it should be granted as a matter of discretion? Now, a lot of times these trial attorneys will not go along with that, but if you work with somebody and they know that you're a trustworthy attorney, you might give it a try and see if you can persuade them not to object to it. They may say, well, I just want to ask your client a few questions, but no, I don't have any serious objection. And that's important because you need their cooperation as much as possible. Because if the judge sees, the judge doesn't want to be faced with anything that controversial, right? The judges are, they don't want to become tomorrow's news headline, right? They want what they're doing to be compliant with the law and fairness, but also not anything really wild or outstanding in terms of taking a big chance on somebody. And if they see that DHS attorney agrees with you, then they're going to feel a lot more comfortable. So
absolutely. It's great when it happens. We've had several cases, like Lory just said, where they look at the evidence and they say, I just have a few questions and then that's it. We've even had cases where they look at the evidence and they say, do you want to just submit it for decision? I'm like, what do you mean? Like, well, I look at it favorably. You want to just submit it for decision? We kind of look at the judge. We get sort of a nod. We're like, okay, we're submitting for decision, granted. So that it's great when that happens.
Right. Yeah. It is great when that happens, and you don't want to make anyone angry or impatient by saying, no, I just want to question my client and put in a lot more evidence. But it is important to do that. If you haven't done that already, you just say, that sounds great to me, Your Honor. I do have this packet of evidence. I'm showing it to the DHS attorney now, and I'd like the court to accept it into the record. Make sure you get that in there, because if anything goes wrong, you've got your client covered. If you get all that evidence. And because later, if the DHS attorney changes his or her mind, and let's say they go back to their office and their supervisor says, wait a minute, what's this, a grant? I thought we talked about that. You were going to fight that one. And so then they take an appeal. I've seen the Board of Immigration Appeals, fairly easily overturn positive decisions granting relief from immigration judges. So you want to make sure that your record is complete and that you've covered all the bases that you need to.
Absolutely. So, sometimes we're going to get decisions from the Supreme Court, perhaps, especially from this one, although they've surprised us with several decisions, let's be fair. But Patel wasn't a great decision. I really had this definition of discretion that I was really going for, which is you need to make an assessment of eligibility first. That is not discretionary. You have to show that. And then discretion is, we don't like the guy because he has a criminal record, something like that. And in fact, in Neil Gorsuch's dissent in Patel, that's what he said. That was his definition. So that's what we were hoping for. It was a close case. It was 5-4, very, very close case. Right. But that's the way it turned out. So our job now as defense attorneys is to find ways in which it might not apply. And so it's our job to protect you. So we have subsection D. So let's mix in some law in there. And there's also the argument, Lory, some courts are not buying it, but the argument is still there that an affirmative application for relief with USCIS, not involving removal proceedings, should not be subject to Patel.
Right. And actually, if you follow a strict plain language interpretation of statutes and you look at 8 U.S. Code 1252, what you will see are particular clauses that make it pretty clear that we're talking about judicial review of immigration judge decisions that went through the Board of Immigration Appeals and now present with a final order of removal. That means an order of removal from removal proceedings.
And Congress is sophisticated enough to where if they want to refer to removal and other affirmative decisions from USCIS, they will.
Absolutely. And that whole section is entitled Judicial Review. And so, it's talking about Circuit Court of Appeals review. So, yeah, you're right, Felipe. We're faced now with a challenge because some circuit courts of appeal have concluded that even if the case did not arise in removal proceedings, even if it went through the affirmative side or USCIS, and if it got a denial there, that a district court does not have jurisdiction to provide review. But it never says that anywhere. Never says that anywhere. And, there are a number of different rules and one that apply to statutory interpretation. And one of them is when Congress says something in one place and doesn't say it in another place, you have to give meaning to the fact that it only said it in that one place. Correct. You can't just take it and apply it across the board to everything. So right now we're actually facing a split in the circuits. There are about 3 circuits that do not believe you can get review in district court. And I can't remember right now what all of them are. I know one is the 10th Circuit. One might be the 6th Circuit. And I don't know. Did you say before that the First Circuit had also?
The First Circuit has not ruled on it yet.
Oh, it hasn't. Okay, great. So we have a lot of arguments to make. I mean, the other thing that I urge people to be aware of is this important savings clause of 1252 B2 capital D.
Capital D.
Right? And that's where you get an exception to go to court for federal court review when it's a constitutional question or a question of law. So that, I believe we can argue, Congress put that in the statute after, in the same section, section 1252, after limiting review under subparagraph B, it then included subparagraph D and in alphabetical order. And so when it was limiting review of certain forms of discretionary relief, it was making an exception to that limitation, saying that, okay, if it's going to limit that relief from removal proceedings, there's an exception if it's a question of law or a constitutional question. So those two, in my view, are linked. If you're going to have one, you should have the other. Absolutely. And I would argue in a district court, especially where the circuit has not made up its mind yet as to whether it will view the preclusion on review as applicable to district court cases, I'd argue, okay, if you're going to have one, you should at least have the other. Now, it still could narrow the cases that would be entitled to review in a district court. But if we are successful in arguing mixed questions of law and fact, and questions of law, constitutional questions, then at least we'll do better there for our clients than if a court would say, no, there's no review of this discretionary relief issue, and the exception for questions of law and constitutional questions does not apply.
Absolutely.
So look out.
Folks, for those of you watching, if some of this seems a little complex, well, that's because it is. But I think you see that, people like Lory and I, we enjoy these challenges. We enjoy defending you. We enjoy giving you that voice and make sure that due process is upheld in your case. The only option when you're going up against the government is to fight, is to prepare the best possible case so you can stay here with your families. Lory, is any conclusion, parting words?
No, I agree with you. This is very complex. And that's why we call ourselves immigration defense attorneys, because we're there to defend your rights and allow you to stay in the United States when you're eligible to, as much as possible, as much as the law allows.
Beautiful. Thank you so much again, Lory, for your time. We learned a ton, and it's always fun working with you.
Same here. See
All
you
right,
soon.
guys. See you next time. Take care.
Okay, bye.